Should you file for divorce before your spouse does? A lot of people who are considering divorce ask themselves that question. Hi, I'm Max Ruthenberg Marshall, attorney and founder of Porchlight. Today we're going to be addressing the question of whether or not you should try to file for divorce before your spouse does. But let's back up a little. Are you even asking the right question? I don't think whether or not you should file first is the most productive question to ask yourself when facing divorce. Instead, ask yourself, what move is going to make this process as painless, productive, and peaceful as possible? I know that might sound hard when it comes to divorce, but I promise you, it is possible. Filing first typically isn't going to be the move that leads to a productive and peaceful divorce. Now, are there some advantages of filing first? Some people seem to think so. In states other than Georgia, you may be able to set the date of separation, which could have legal advantages in your case, but that doesn't actually matter here in Georgia, so there's no benefit there. Some people think if they file their petition before their spouse and allege fault in the divorce, that they'll be putting their spouse on the defensive. But let me tell you, the divorce process is so long and complicated that one move really doesn't give you much of an advantage, even if your spouse is feeling defensive at first. Another thing that comes up is the person who files first, called the petitioner, gets to present their case first at trial. Some people do view this as a benefit, but even if you are the respondent, the person who files second, your attorney should be able to plan accordingly for the fact that they will not be presenting your case first at trial. They'll be going after the petitioner's attorney. That's fine. Your attorney's done this a bunch of times. They can plan for it. The other thing to note is that most family law cases don't actually go to trial. So just planning for this one little potential advantage at trial may not be the best overall strategy for your case. There is a pretty big disadvantage to being the first to file. Filing means you're asking the court for a contested case. You're telling the court that you need help figuring out all the puzzle pieces of the divorce between you and your spouse. So that's division of assets and debts, parenting time, child support, and alimony. That can feel like a slap in the face to your spouse, and it does put them on the defensive, which is not always, and I would say not usually, the best mood for someone to be in if you're trying to have an amicable divorce process. Contested is like throwing the first punch. You've started the fight. Instead of trying to talk to your spouse and work things out, work through this problem and disagreement that you're having to come to a resolution on your divorce, you're saying, whatever, I give up, let's just fight. In an uncontested divorce, you're actually working things out with your spouse. It usually saves time, money, and stress. And then it doesn't matter who actually files the case, because all the paperwork will be signed, and one of you will take on the role as the petitioner because it does have to be moved through the courts for the judge's approval. In my experience, most cases go better if instead of trying to rush to the courts and be the first to file, you actually talk to your spouse, find an attorney who's going to help you with an amicable case, and try and work things out and have an uncontested divorce instead of a contested divorce. Porchlight can help you avoid a messy, nasty, high-conflict divorce. Give us a call to see how we can help you through your divorce as painlessly as possible.